Here's our Constitution, and here's our legislature. They go out and pass a licensing law to license people to drive on the roads. Now, either the Constitution is a superior law or it's an inferior law. One or the other. That's what your Supreme Court said. And remember what I've told you. Don't believe anything I tell you. I hadn't known the law until I read Marbury versus Madison. How could I understand law? I was born in 1939. When I came into the world, I didn't know anything. And everything that I know came into my mind through my five senses. That's the way I found out what I now know. So here I simply go to my Supreme Court and I say, well, let's see if we can figure this out. Do you fellas count out there in Washington? They claim to be the highest court in the land. They claim that what they say is the law of the land. They say that when they say blacks don't ride the back of the bus, no mo, blacks don't ride the back of the bus. Now, it happens that I've heard reports that down in Alabama, blacks don't ride the back of the bus anymore. I think those guys out in Washington do have some power. If they don't, then there's no hope for us, and our legislatures in our respective states are in fact the sovereigns, and they will decree to us the way we will live. It happens that I don't believe that's it. I think that those powers of the legislature are limited, and I think that the Supreme Court understands that. I think that what you and I have got to learn how to do is to go into that court and get the court to order the legislature to get off our backs. That doesn't mean that the court is going to order the legislature to rescind, change, or in some way abrogate law. That's not their job, and that's not what they're going to do. What we're going to do is go into the courts and get the policemen to quit messing with us. Don't mess with George Gordon, because if you do, he's going to sue you under Title 42 and collect a lot of money. Going on, where it says certainly. Certainly, all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation. And consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Let me read that again. It says here that an act of the legislature repugnant to the Constitution is void. Now remember, this is written in 1803. Okay? 1803. This case is quoted continuously. This is still the law of the land. A lot of lawyers will tell you, well, gee, that case, you know, is 180 years old, so it must be done away with by now. That's the way the law schools teach these fellows, as far as I can tell. I want to turn over now to a case called Norton versus Shelby County. You've probably heard this term before if you've been around in conservative politics or in any kind of pro se law. It's the one that says an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Now I'm going to read that again. I'm going to run through it a little more slowly. There's two things that I want to comment on here. When I first saw that quotation, it's an extremely important quotation. It's simply telling you here that an unconstitutional law is void. Now listen to this again. This comes from a case, by the way. I want to give you the citation on it so that you can find it for yourself. 1886, I believe, is 118. So this must be 118 U.S. 425, and it's called Norton versus Shelby County. Write that down in case you don't have it in your book. It's Norton versus Shelby County. It was decided May 10th, 1886, and I believe that 1886 in the U.S. Supreme Court reports is volume 118 U.S. 425. Now, the only comment in that entire case that's of any great value is this one, and it's on page 442. Let's read it again, because this is real power. An unconstitutional act. That's an unconstitutional legislative statute passed by the legislature of your state. I don't care what it is. An unconstitutional act is not a law. I didn't write that. Don't get mad at me. You policemen and lawyers and all of you bureaucrats out there, I'm telling you that the Supreme Court of the United States said in 1886, and as recently as 1968, when in the Miranda Doctrine, the Supreme Court said that where rights are involved, there can be no legislation or rulemaking that would abrogate them. Rights. Where rights are involved, there can be no rule making or legislation that would abrogate them. And so here in 1886, Marbury, Norton versus Shelby County, and Miranda versus Arizona all say the same thing in different words. An unconstitutional law isn't law. Now, it doesn't mean that a statute is unconstitutional because of the way the statute's written. It's unconstitutional in the way that it's applied to you. So you need to change your status. You need to change the way that law applies to you if you don't want that law to work upon you. In any event, an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. The law is unconstitutional from the time it was created and not from the time it's overturned. Okay? Now, one other thing. That quotation appears in Amjur. I think it's 16 American Jurisprudence, and I forgot the page. But remember that Amjur is not the case. Now, it's a good quotation. It's an axiom in law. I think most appellate court judges would recognize Norton versus Shelby County immediately. But always use the Supreme Court citation. Remember, we're not lawyers. When we go into the courts, we want to be armed with the facts. We want to be armed with the case. We don't want to be armed with a definition from Black's Fifth. We want to be armed with what did the Supreme Court say about that subject. And that's what the Supreme Court said on that subject of an unconstitutional law. They're simply saying here exactly what we have from Marbury versus Madison, that an act of the legislature repugnant to the Constitution is void. Now that's both the law and the laws that applies to you. Because if you're not under that law, if that law doesn't apply to you, it's unconstitutional if you try to apply it to that guy. If then, I'm down at the bottom of the page, we'll skip through, we're on page 389, Marbury versus Madison, drop down to the bottom of the page where it says, if then the courts, here's a few more keen statements. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such an ordinary act, must govern the case to which they both apply. Well, I'm talking about driver's license. And if I'm going to bring up the Constitution and the cases that the Supreme Court has used, declaring liberty and rights of way, and taxation, and driver's license is a tax, and registration is a tax, etc., then I'm going to have to lay out my position in spades, and it's got to be laid out from the Supreme Court of the United States. I'm contending that an ordinary act of the legislature cannot supersede my constitutional rights. Going on, those then who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that the courts must close their eyes on the Constitution and see only the law. Let me tell you, friends, that's what our courts do. They close their eyes to the Constitution and they'll sit there and argue statutes. Prosecutors, they do that. Well, we don't talk about the Constitution. See, the statute says that you've got to show your driver's license, Gordon, and we want to see your driver's license. Well, what about the Constitution? We don't talk about the Constitution, just the statutes. And they're reduced then to the necessity, you hear that? They're reduced to the necessity. They are controverting this plain doctrine of the Supreme Court of the United States. These courts out here and these prosecutors don't obey the Supreme Court. They don't even know the Supreme Court exists. And when they do acknowledge it, they think that there's a bunch of crusty old fuddy-duddy judges who take votes and whose opinions change with the winds of doctrine every week. And that what is the law concerning Miranda 1968 isn't the law 1969, 70, 71, or 2. Had a judge tell me the other day that Miranda was dead. Miranda is no longer law. It's been superseded and changed, and it's no longer the law. No, I didn't know that. I've read some cases where the Supreme Court keeps quoting Miranda. They keep acting like that they haven't changed their minds on it. I wish the Supreme Court would get out here to our law schools and start teaching some of these guys which end is up. I think that these people are trying to subvert our rights and trying to rule over us with a rod of iron. I think that's what our real problem is. The Supreme Court's probably one of the last friends that we've gotten so far as individual rights are concerned. Now, there are some good judges here in the appellate courts, and they seem to understand this doctrine of rights. But we live in a slave state, and we've lived in a slave state now since 1860. And with the slave state mentality, I mean, you can sit here and say, well, we live in the freest country in the world, and I'll agree with you. We live in the freest slave state of 142 slave states on the face of the earth. This is the best slave state to live in, but that doesn't make it free. We still have to have our papers, and our papers have to be in order before we cross our state boundaries. And you'd better have your documents if you want to drive downtown. I contend that those are the attributes of a slave state. I contend that if a man has to have a piece of paper, a document from his government to work, that he's a slave, he's a serf, he's a coolie. Now, there was a time in America when you didn't need a driver's license to drive and you didn't need the government's permission to work, but today you need that. And if you don't have that, you can't work. And I'm sitting here telling you that the Supreme Court of the United States will recognize your rights. But we have a Republican form of government, and our Republican form of government can't work unless you'll demand your rights, be a belligerent claimant in person, and go in there on the courtroom floor and make it work. Otherwise, we're going to have a democracy, which is what we really have. We have a Republican form of government under our Constitution that doesn't work because we don't make it work. We have a democracy because mobs rule our country. You have to belong to this big mob. You belong to the Gray Panthers, or the Pink Panthers, or the this Panther, or that Panther, or the Ku Klux Klan, or you belong to this group, or this association, or this trade organization. And then you hire these lobbyists, and they go back here, and you have this tug of war, you know, constantly back and forth. Nobody talks about rights. Nobody says, wait a minute, I'm not a taxpayer. Everybody says, well, what we're complaining about is that our masters are ruling over us too heavily. See, they're imposing too heavy a tax. They're imposing too heavy a restriction. I don't hear very many people saying, hold it. Hold it, guys. I don't even want to talk about taxes. I'm not a taxpayer and I don't pay taxes. I'm a freeman. Hold it. I don't care about driver's licenses. I don't have any. I'm going to drive on the road as a matter of right. What we're talking about is, well, I'll take the driver's license. What I object to is having to breathe into the balloon. If you got the driver's license, shut up and breathe into the balloon. That's one of the terms and conditions of the contract. It's just that simple. You don't have any Fourth and Fifth Amendment rights. All right, going on then on page 390. This doctrine would subvert the very foundation of all written constitutions. That is, if we were to accept the premise that the legislature can just make whatever law it wants and the Constitution, you know, doesn't have to be thought of or listened to, that doctrine, if that were true, would subvert the very foundation of all written constitutions. It would declare that an act which, according to the principles and theory of our government, is entirely void, is yet in practice completely obligatory. They tell me that all the time. To hell with the Constitution, Gordon. The law says you got to have a license. It would declare that if the legislature shall do what is expressly forbidden, boy, let me tell you, here in Idaho, this legislature, they just do what is absolutely forbidden in our Constitution, both state and federal. Such act, notwithstanding the express prohibition, is in reality ineffectual. Now, there's nothing wrong with our government passing unconstitutional statutes and acts. That is, the Supreme Court's not going to come out here to Idaho and say, okay, you guys can't have that law because it's unconstitutional. We had a law here in Idaho that violated our state constitution for 16 years. They were splitting counties down the center. And somebody took it to court up in the north end of the state. And I heard a fellow tell me, well, it's been on the books for 16 years. They've been violating the law for 16 years, and so what does that make it, right? So this district court judge says, yeah, the Constitution says plainly that you can't split counties. That's the end of the argument. So the judge, if you will go into the courtroom and challenge the law and ask the court to make a decision, they'll make a decision. Well, my question was, well, who was it during that 16 years that went into court to challenge that illegal practice of our legislature and of our executive branch of government? If nobody objects to it, then it must be acceptable. Who's been objecting to Federal Reserve notes lately? Oh, I hear a few incompetents running around in the courts arguing the money issued under Article 1, Section 10, but they don't know what they're talking about. And so now the courts look at it as being a phony issue nationwide. We have a book here on this money issue, about 308 pages, written by an attorney who's also a law professor on the subject matter of money and gold and silver, and wrote it to the Gold Commission, established, I think, by President Reagan. Anyway, whoever established the Gold Commission, I'm not really sure it was Reagan, but maybe it's Carter, but in any event, whoever established it, we have a commission studying gold and silver. I mean, there's an issue there, all right, and this fellow said that there isn't one logical case that's gone before the courts yet. We've got one here in Idaho, and we hope that we're logical, and we hope that we can get it before the Supreme Court. We'll see whether or not we're as logical as the rest of the incompetents around the country. Going on, then, it would be giving to the legislature a practical and real omnipotence with the same breath which professes to restrict their powers within narrow limits. It is prescribing limits and declaring that those limits may be passed at pleasure. And our legislature just passes its limits with pleasure, or at pleasure. Going on, skip the next paragraph where it says, we'll take it up again where it says, the judicial power of the United States. We're on page 390. The judicial power of the United States is extended to all cases arising under the Constitution. Could it be the intention of those who gave this power to say that in using it the Constitution should not be looked into? That a case arising under the Constitution should be decided without examining the instrument under which it arises? This is too extravagant to be maintained. I'd say that's an understatement. But here's your Supreme Court then telling you that this is too extravagant to believe. It's bordering on idiocy to even consider it. In some cases, then, the Constitution must be looked into by the judges, and if they can open it at all, what part of it are they forbidden to read and obey? Well, the lower court judges in this state are afraid to look at the Constitution. They're afraid of losing their jobs. They're afraid to make decisions. They'd rather rule against the citizen and let it go on up the ladder. Let it go up the appellate ladder. They're afraid to make judicial determinations. Listen to how scathing the attack gets from the Supreme Court upon such judges. It is declared that no tax or duty. Now, wait a minute, I missed a little part here. In some cases, let's start out where it says, in some cases, then, the Constitution must be looked into by the judges. And if they can open it at all, what part of it are they forbidden to read or to obey? There are many other parts of the Constitution which serve to illustrate this subject. So here's some more examples. It is declared, this is Article 1, Section 9, it is declared that no tax or duty shall be laid on articles exported from any state. Let's suppose that a duty on an export of cotton, of tobacco, or of flour, and a suit instituted to recover it. Ought judgment to be rendered in such a case? Ought the judges to close their eyes on the Constitution and only see the law? That's what they do here. They just close their eyes on our Constitution, and this is what the law says, and if you don't like it, you can appeal it. We shouldn't have to appeal. Our judges are supposed to rule on our Constitution, and if we don't like their decision, then we can appeal it. The Constitution declares that no bill of attainder or ex post facto law shall be passed. If, however, such a bill should be passed and a person should be prosecuted under it, must the court condemn to death those victims whom the Constitution endeavors to preserve? They prosecute people here every day by information. Haven't had a grand jury in this state for 18 years. I've heard it said. I don't know when the last one was held. I've never heard of a grand jury being convened in Idaho. If you know of one, let me know, would you? Because I haven't heard of it. They do this every day. They subvert and violate our constitutional rights every day, and no citizens or none of these alleged criminals ever complain. How can they? They've been to the government schools. They're functional illiterates. They know 2% of the English language. They can't read and write. And until we took up this lesson today, probably you couldn't read. At least you couldn't read legalese. I know I couldn't read legalese until I was 37, so how could I go in the court and argue an information versus a grand jury indictment? I couldn't even read nor understand the law. These are some pretty good words from your Supreme Court. I'm always encouraged. When I get despondent, I always go pick up Marbury or Miranda or some of the case by the Supreme Court just to let myself know that there's still some people left in the United States that have some common sense and understand some law and individual rights. No person, says the Constitution, shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. So here's your Constitution saying, open court, 2 witnesses. Treason's the crime. Here the language of the Constitution is addressed especially to the courts. Here's a command to the court. It prescribes directly for them a rule of evidence not to be departed from. What if the legislature should change that rule and declare that one witness or a confession out of court sufficient for conviction? Then must the constitutional principle yield to the legislative act? From these and many other selections which ought be made, it is apparent that the framers of the Constitution contemplated that instrument as a rule for the government of courts as well as of the legislature. Constitution binds down the courts and prescribes their powers, their limited powers, tells them what to do and what not to do. Going on about halfway down the page, why does a judge swear to discharge his duties agreeably to the Constitution of the United States? If that Constitution forms no rule for his government, if it is closed upon him and he cannot be inspected by him, if such be the real state of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. So here we've got judges that blather like coat sleeves flapping in the breeze an oath of office to support the Constitution of the United States. And when you walk into the courtroom and you bring up a constitutional issue, they'll say, well, you're going to have, they'll rule against you almost every time. I don't know where they got started doing that, but it's time that we changed it. It is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. Laws that are made in pursuance to the Constitution are the laws. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. And there it is, your Constitution. Well, it's fortunate for us that our Supreme Court at least knows what the supreme law of the land is, even if the lower courts, or some of the lower courts, and I shouldn't say that about all judges. Our estimate here in Idaho is that probably 90% of the judges in this state know and understand the law, but for some reason they're a little timid. I think they're trying to protect their pocketbooks and they want to protect their jobs. And we've got a real problem here in Idaho for that reason, but the reason or the cause of our problem is caused by we the citizens. We go into the courts and they prosecute us by information and, oh yes, sir. How do you plead? Not guilty. Or I plead guilty with an explanation, sir. Let me confess to you. Let me tell you how I broke this law. Instead of having citizens that have some backbone, we've got a bunch of spineless jelly bellies here that are afraid to go into the courts, and then they're just the rubber stamp of the lower courts that tell them, find this guy guilty. All right. Let's talk about fact pleadings and how those apply to motions. When you get into a motion, and I'm going to go through a couple of lessons on motions, because starting with this lesson, we're getting into the nitty-gritty now of the courtroom procedure. And you're going to have to pay close attention, or you're going to have to go over the material 2 or 3 times. I'm going to give you some nifty stories and show you how we've used this from time to time and how it works in the courtroom and what the strategies are. But, the first 10 or 15 lessons you have to go through to find out what you're doing wrong. Then once you find out what you're doing wrong, then we can begin to change the wrong habits and the wrong confessions, admissions, and scene of the crime and the jailhouse scene, etc. And we can get down to how do you live like a free man? How do you go downtown without having documents and papers? Well, you better be able to argue your position, because when you get into the courts, they're going to say, why didn't you get your documents? It's the law, To which I say, balderdash, it isn't the law, and I don't need those documents. Unless I'm a person who's engaged in some kind of a regulated enterprise, which might come under the police powers. So when you're talking about fact pleadings, then, we're talking about facts, okay? Let's just for a moment discuss what is a fact. We like to use the word truth in the courtrooms, and you've probably heard the term, do you swear to tell the truth, the whole truth, and nothing but the truth? I contend that the truth is not the proper subject matter to be swearing an oath to, because truth is, by definition, in Scripture, if you want to talk about it, what is the definition of truth? It says, thy word is truth. Christ said that about the Scripture. All right, so truth then is the Scripture. And I'll contend, yeah, it's probably true. Then you're told to tell the whole truth. Do you know the whole Scripture? Do you know all of the Scriptures, all 66 books? Well, I don't know the whole truth. So, since I don't know the whole truth, I can only know some truth, and the some truth that I know isn't a proper subject matter in the courtroom. I've never gone into the courtroom and espoused the parable on the parable of the sower, or the Beatitudes or something in the courtroom. I haven't seen any need for that. I'm talking about facts. Now, if you want me to relay to you or relate to you in the courtroom what the facts of the matter are, yes, I saw the truck driving down the road at an approximate speed of 50 miles an hour. Well, could it have been 45 miles an hour? Well, it could have been. Could it have been 55 miles an hour? Yeah, it could have been. Could it have been 90 miles an hour? No, couldn't have been 90. See, those are facts that I can testify to. All right? When you get into the court, then we have to talk about facts, and the court wants to know what facts are. So you're going to plead the facts of the case, not the truth. You're going to plead the facts. I'm going to tell you what I know. I'm going to tell you the facts of the case, not the truth of the case. Now, they use the word truth in the court, and so you're supposed to sit there and say, well, I'm going to tell you the truth. Oh, okay. That's like saying, I'm going to tell you the Scripture. And the judge would sit there and say, why are you going to tell me the Scripture? What we want to know is, what are the facts of the case? Do you owe the money or don't you? Let me give you an illustration. I was in court yesterday, and there was a very nice lady, and she's just a real sweetheart of a lady. And she went to a hospital, and I think it was her husband went to the hospital, and they ran up a $2,000 bill. Had an emergency, right? So they go to the hospital, and here's this emergency, and somebody says, sign here, sign here, and sign here. So, oh yeah, they never read or negotiated or talked about terms of payment or anything else. They just signed all the documents. Well, I sent them a bill for $2,000. She couldn't pay $2,000, so for about a year she's been sending them $10 or $20 a month. They've accepted $10 or $20 a month. Now, some lawyer comes along a month or so ago and files a claim. We want $2,000 plus interest. Plus now I want $1,000 for attorney's fees. So they go into court, and this lady, she's real nice, and she wants to be honest and fair and square, and so she files in her pleadings. She says, yes, I owe the $2,000, but I don't owe this extra $1,000, and I don't want to pay the extra $1,000, and I think this lawyer is guilty of barratry, and I think that this is wrong, and I never agreed to pay the hospital $2,000 cash. The hospital knew that we didn't have any money. The hospital knew we didn't have insurance, and we said that if we did have insurance, that we would sign it over to them, and they signed a waiver of any medical benefits from insurance would go to the hospital, and there was a primary lien. You hear all these facts. Those are facts. Facts of the case. And she filed those facts of the case, and she went into the courtroom. And so here sitting on the right is the attorney for the hospital, and here's this lady appearing pro se. Now, the lady had filed an affidavit of defense and several other motions to outline her position and to demonstrate why it was that summary judgment should not issue from the court in favor of the hospital. And so here's summary judgment comes under what's called a rule of civil procedure. And so the hospital simply says, as a matter of law, as a matter of contract, no rights and issues involved, this woman owes us $2,000. We want our $2,000. We have it coming to us as a matter of right. So her position then has to be, or should be, or could be, let's say could be, 2 or 3 positions. 1, no contest. 2, not guilty, and I don't owe you anything. I'm not paying you anything. Well, what else could she have pled? Let's see. She could plead no contest, and they take the summary judgment. She could plead the fact that, or these facts, that she doesn't owe the hospital anything because she didn't know what she was signing when she signed the contracts. The contracts are null and void. Well, let me tell you what she did do. She went in there and she, like going to the priest, or like, I've got a couple of daughters, and So I'll just kind of use this little analogy. You know, I've got a daughter, she comes up and says, Kathleen did this or that to me, and Kathleen is bad, and Kathleen, did these bad things to me. Well, okay, Elaine, I'm going to punish Kathleen for doing these bad things to you. Kathleen, come here. And Kathleen will then have her story, and she'll tell her story. And Kathleen will say, well, Elaine started it. Well, Elaine came into my room. Well, Elaine took my books. And, well, Elaine did this or that. And so here I am then cast in the role of God. Should I cut the baby in two? Should I give the baby to this mother? Should I give the baby to that mother? Here's Solomon all over again. And this is the way this lady walked into the court. She expected the judge to play God. She's been to the government school. And she had the mistaken notion that the court works this way. That as soon as she went in and said, Your Honor, there's a recession. Your Honor, I'm poor. Your Honor, I've been making payments. I've been paying them $20 a month. And this just isn't fair, and you shouldn't burden me with another $1,000 bill from this lawyer who's only suing me so that he can harm me, so that he can vex me and harass me, and so that he can make $1,000 and use the law and use under color of law, or use the law to color his evil and wicked intent. And so she wanted the judge to say, you're right, lady. You know, like I would with my little girl. Well, now, Kathleen, here's the way I'm going to decide this between you two girls. And so most people walk into the court, and they're just real nice, honest folk, and they just want that judge to act as God or to act as Father and to do what's fair, which is equity. Be equitable with me. I'll pay the $2,000, but Judge, I want you to tell that lawyer to go home with nothing. When the judge sat there on the bench and said, Madam, I'm not here to take sides. There is an issue before the court. The only issue before this court is, do you owe that hospital $2,000 or don't you owe them $2,000? Well, but, Your Honor, you see, this lawyer came in and he put this extra $1,000 on here, and, well, I've been making these payments of $20 a month. And, well, my husband was hurt and we had to go to the hospital, and, well, it was this, and, well, it was that, and, well, there's all these excuses. The judge was very patient. And he said, Madam, I don't have any of those issues before me. The issue before the court is, do you owe that hospital $2,000 or don't you? Well, yes, I owe them the $2,000, but. Well, yeah, I went in and took the services, but. It was an emergency, you see, and I've been paying $20 a month, and gosh, and gee whiz, and why don't you, why? And the judge says, okay, now, the issue is, do you owe the money? And you admitted that you owe the money. You've admitted that you owed the money on the record. They have moved for summary judgment pursuant to Rule 56. Do you know of any lawful reason why I should not enter judgment in favor of the plaintiff for $2,000 as a matter of law pursuant to Rule 56? Well, Your Honor, but, and well, you see, and they've got dirty hands, and well, you see, and here comes all the excuses. When you go into the courtroom, my friend, there's issues. There is procedure. You go in there, and her proper response was, no, I do not owe them $2,000. I do not owe them $3,000. They've come into court with dirty hands. And there's a contested issue of fact, and here's what it is. The contested issue of fact is that the contract that I allegedly signed was signed under threat, duress, and coercion. The contract that they're alleging is a lawful document binding me to specific performance is null and void because, under the rules and the laws of contract, thus and so is a fact of law. And that I signed it, but I didn't know what I was signing, and a contractual agreement cannot be made by fraud. I'm charging as a matter of fact fraud on the hospital. I'm charging as a matter of fact that I didn't know what I was signing. I'm charging as a matter of fact I do not owe $2,000. I'm charging as a matter of fact barratry under Idaho statute for facts of law. Now the judge would say, oh, Mr. Plaintiff, would you like to answer the defendant's argument? Now the plaintiff is going to have to say, Your Honor, she signed the contract knowingly. Your Honor, she signed it voluntarily. And Your Honor, I'm not guilty of barratry. Why gosh, I'm just here trying to get my reasonable fee. You see, the facts and the facts collide. Bang. And that's called a contested issue of fact. That has to go to the jury. Then she would have qualified to go and take her case before the jury. And the jury then could listen to her story and her argument. And the jury could go back into chambers and say, well, based upon our everyday garden variety lives, this honest woman is just doing everything in her power to make these payments and to pay. And this dirty scoundrel lawyer is just trying to gig her for another $1,000. Therefore, our judgment it will be. And there would have been her opportunity and her chance. And if her matters of fact under the law were law, she could move for summary judgment and maybe win. Probably not, because, remember the plaintiff saying, no, she signed the contract voluntarily and she knew what services she was getting. But you have to deny every material allegation and fact on the face of the complaint. And by going into court and saying, well, gee, I owe the money, and gosh, I'm just trying to be a real nice person, her misunderstanding of the way the court works now granted the summary judgment to her opponent plus $1,000 to boot. Now, she's a nice lady, and maybe she'll graduate from school one of these days, but sometimes you have to go through those lessons, those hard knocks. But you don't need to go through those hard knocks. If you think you want to be an honest, above-board, nice, respectable person and walk into the courtroom and say, yes, I owe the $2,000, the judge is going to rule against you, and then now she has this extra $1,000 to pay. And she's hurt. And she thinks that the judicial system is bad, wicked, terrible, and awful. And she thinks that she's been put upon. And I think she's been put upon based upon her own ignorance. The judge didn't make a bad decision. The judge made the decision, which is his job to do. Her problem is that she's been to the government schools and she thinks that the courtroom is the fairyland Wizard of Oz, and that there he sits and he's God, and that he's going to make the right decision, and that he's not going to cut the baby in two, that what he's going to do is give the baby to me because I'm the rightful mother. And then the judge gives the baby to the other party based upon statements of fact. And those are called fact pleadings. Just telling you. There are facts of the case. There are facts of law. And if you're going to contest the facts, then you've got to say so plainly. You've got to be the belligerent claimant in person. Now let me show you how I'm handling this. Let me give you another illustration. Now remember I told you the hospital story. Okay? I have a case here, and I call it the child abuse case. My little girl had a lump on her back. Now I don't happen to have a lot of money. Don't even happen to have a little bit of money. And I recognize that, and there's this lump on her back, and like any father, you look at your little girl, and she's in pain, and she's crying, and you say to yourself, what can I do for my little girl? Now, some of us have strange and bizarre beliefs. Some of you people watching this tape are Jehovah's Witnesses. Some of you are Catholics, and some of you are Jews, and some of you are Protestants, and some of you belong to some splinter group religious organization. And I happen to be one of those that believes in these splinter group kinds of religious philosophy. For instance, I don't think that medical doctors are the answer to our health problems. Now, I'm not condemning hospitals and doctors. I think doctors are wonderful people. A lot of doctors take this course. A lot of doctors make their livings by operating on people, and a lot of doctors work in hospitals, and I think hospitals are great and wonderful places. I just don't happen to think that they're great and wonderful places for me or for my family. Okay? And I don't want to inflict, I don't want to compel other people to think the way I think, or to act the way I act, or to do what I do. What I want is for everybody to be free to make his own decisions, whether they're right or wrong or good or bad. I want you to be free to fail. I want you to be free to make $1 million. I want you to be free to lose the $20,000 you've already got. So, remember now, we have laws and we have statutes and we have government, and our government in the state of Idaho says that you've got some child abuse statutes. Okay? And I'm going to read three of these to you in a moment, but I want to give you the background. So here's my little girl, and she's in pain. Now I'm sitting here with a couple choices. We don't have any nature paths left in Idaho. Or there maybe is a couple of them left, and they're over on the east side of the state, or they're out hiding underground or something. But I was the kind of a guy, we used to have our babies at home. We're strange and weird kind of people. Babies, we thought that was a natural process, like going to the bathroom. We thought women had babies just like cows have calves, you know, and we just strange people. We didn't think you had to go to the hospital to have a baby. We have this guy called a nature path, and that's called like Luke the physician, as opposed to Luke the medical doctor, or Luke the witch doctor. You know, we thought we'd go to a nature path, and so we used to have those, but they took our nature path and they put him in the prison out here on the desert because he's a bad, wicked, terrible, awful fellow, and he, you know, treats people, and he didn't have a license to do that, and so he's bad, and the king threw him in the dungeon. So I had to make a decision, didn't I? Either you got to go to Ontario to a nature path, or you have to go to a chiropractor or a medical doctor or somebody else. Took my little girl to a chiropractor. I thought maybe she had a broken bone, or the bone was out of position and it caused some swelling. Boy, this chiropractor looked at her and he just, oh, you take her to the hospital. Oh, what do you think that is? I don't know. It's a swelling in her back. Yeah, I can see that. And it's very painful. Yeah, she's crying. She's been telling me that's painful. What should I do about it? I don't know. Well, paying that guy $30 wasn't any big deal. I could see that it was painful. I could see that it was a swelling. I knew I didn't know what it was. I took her to a chiropractor. He told me the same three things. There's a swelling in her back. We don't know what it is, and we want $30 to tell you that. I didn't need to pay the guy $30. I could figure that out. She told me it hurt. I believed her. Tears coming down her face. Took her to the hospital. Okay? Goes into the hospital. Hospital says, she's got a lump on her back. It's a swelling, and it's very painful. Yeah, that's right. You got that right. Now, what is it? What caused it? What do we do to make it go away? We don't know. Oh, we'll take her up to the 4th floor and we'll put her into isolation and we'll look at it and we'll do some tests. Now, there's the first good advice I've received. We don't know what it is. We're going to put her through some tests and we're going to find out. Next morning, I come in the hospital. Hi, gosh, how you doing? Hey, my little girl's in here, you know, Elaine, and she's got this lump on her back. Mr. Gordon, we put her through a CAT scan for $1,645. We took 35 x-rays of her, probably gave her cancer, and she'll die now by age 30 from radiation poisoning. And we put her through about 10 or 15 tests. And I mean to tell you, we have got bills in here. I'm not kidding you. This is my file here. I mean, I got bills and bills and bills. Look at the bills. It was $8,000 in 7 days. Now, I'd say that hospital's got a billing staff. I don't know if they got any doctors or nurses in there, but by golly, they sure got some billing staff. Next morning, what's wrong with my little girl? We don't know. Let me see if I understand this. You took 35 x-rays.